Law Journal would like to thank the following for making tonight's programming possible. McElnay and Waterpolo, serving its clientele with estate planning, taxation, and other disciplines affecting the elderly and their caregivers. Verona, Rivervale, and New York City. Bagley and Fenrick, a practice emphasizing elder law, Medicaid planning, estate planning and administration, and real estate. Morristown, Princeton, and Avalon. Solnick and Solnick, a diversified practice with emphasis in elder law and elder rights, including nursing home and guardianship issues. Plymouth Meeting. Lippman, Crooks, Roth, and Ball, an elder law firm concentrating in rights of the elderly and disabled, including estate planning, asset preservation, and long-term care issues. New York City and White Plains. New Jersey Lawyer, the professional newspaper of choice for New Jersey attorneys. And the Legal Intelligencer, Philadelphia's oldest law journal and daily newspaper for Pennsylvania lawyers.
Chance to see these folks but once a year, and we've already gone through the first half hour of our hour-long program. We're discussing elder law tonight, so again, if you've got some questions on nursing homes, guardianship, power of attorney, estate planning, and the like, we will try to entertain those questions as quickly and as succinctly as possible. I have two New Jersey attorneys with me tonight, one from Pennsylvania, one from New York City. To my immediate left, Brenda McElnay and Thomas Begley are the attorneys from New Jersey, again in practice for quite some time, and again, known throughout legal circles and lay circles for their work in elder law. Again, prominent members with the New Jersey State Bar Association's Elder Law Section, and also with NALA, the National Academy of Elder Law Attorneys, as are the two other attorneys joining us tonight, Nancy Solnick and Howard Crooks. Nancy from Pennsylvania, from Plymouth Meeting, again, a founding member of NALA, the National Academy of Elder Law Attorneys. Nancy has been practicing for some time with her husband. That's the other Solnick in the Solnick and Solnick group, and again, seated next to her is Howard Crooks from Littman, Crooks, Roth and Ball in New York City and White Plains. And again, Howard's first time on the program, and you're enjoying it so far, Howard, are you not? Thank you for also filling in for our New York slot now that we are seen on WPXN in the greater New York area. Again, folks, that 1-800 number will be appearing in the lower left-hand corner of your screen. If you've got any questions or comments on elder law, go ahead and throw them at us here in the last half hour of the program. What would you say today is probably the most challenging aspect of your practice? Probably, that might, wrench a couple of hearts out there, the kinds of things that you have, not difficulty, but are challenged both legally and emotively today. What would you say are some of the top issues today?
I think one of the big problems is this estate recovery that we have in New Jersey that you don't have yet in Pennsylvania or New York, emphasized the yet, because they recover from the estate of a deceased Medicaid recipient anything they had, including a home that's owned by a husband and a wife. So if dad gets sick, goes to a nursing home, and dies, then Medicaid puts a lien on that home, and they don't throw mom out on the street, but they will collect when she dies up to 100% of the value of that home. And to me, that's really picking the bones of the poor. They don't do that they only do that if you have something like Alzheimer's disease. If you have a heart transplant, Medicare pays for that because that's acute care. But if you have some kind of a disease like Parkinson's, Alzheimer's, that's chronic care, then they're going to take your house away from you. So we have to find a funding mechanism to fund chronic care similar to the way we fund acute care.
Brenda, when we've talked on this program before, we've talked about the fact that most elder law attorneys are champions of the elderly, the disenfranchised. They are a minority as well. I mean, they are, in fact, in many ways less powerful than other minorities in our society. And especially when it gets to issues such as nursing homes, do you find that you sometimes have to be a champion, in addition to being the estate planner, in addition to worrying about the other instruments such as power of attorney and guardianship? Do you find that you have to get into your litigator's mode, that you have to be in contact with the nursing home or with someone that is not treating your client as well as he or she should be?
We do have to watch after our clients who are in nursing homes, and we have to watch after nursing homes. Well, I think probably one of the most common abuses that we see is that if payment is not forthcoming to a nursing home, and it could be because we've made a Medicaid application and there's not yet a determination, our client can be sent, or the client's spouse can be sent, a 30-day letter. We're going to discharge your husband, and we're going to bring him home in a cab and put him at your door. And of course that can't happen. There has to be a safe discharge plan and so on. There are steps to be taken, but you have to get in gear and contact the right people.
When a lawyer sees something like that, you send that to a lay person, of course, the first thing they're going to do. An elderly person is going to get really scared, but you send that to a lawyer, gets your ire up, does it not?
It's very upsetting because, first of all, it's illegal. It can't be done.
Exactly.
They're not permitted to do it. That's first of all. Second of all, we are trying very hard in our practice to have good open lines of communications with the nursing homes that our clients are going into. And for the major part, that is true. Where if we call and talk to the administrator or the admissions person or one of the social workers, we get a very good response to the issues that we're bringing forth on behalf of our clients, so that we don't get into the litigation mode.
I agree, but however, this client will become a client of ours at the time that they receive the 30-day letter. It's not that they've been. We also try and have good working relationship with the nursing homes and the social workers, administrators, all of the agencies that we deal with, Medicaid as well.
Of course.
But this will be someone at home who gets that 30-day letter and then will call us in a panic.
Well, you know, you say they can't send them home in a cab, and that's true, but what they do is they send them to a hospital, and then when the guy's ready to be discharged from the hospital, they refuse to take him back. So...
Isn't that just as egregious, or they just...
It's just as egregious, but it's harder to prove.
I see. Howard,
We don't really see that. We don't really see that being acted out in our area.
Most of the nursing homes in our area provide very good care, and it doesn't happen either, but there are some who do.
In our area, the hospitals will lean on the nursing home to take them back.
Yes.
They can't
Howard,
get away with it.
would you say that, true or false, that a person who goes to an elder law attorney prior to going into a nursing home has a better shot at being, A, getting into a better nursing home, and B, being treated better at a nursing home, regardless of the one that he or she goes to?
Well, I don't think it's so much getting into a better nursing home, although we've established through our practice relationships with nursing homes throughout Westchester County, all the 5 boroughs in New York, as well as Nassau and Suffolk County. So by virtue of having come to us and our relationships that we have developed, there is a chance that you will get an admission to a nursing home of your choice, because who's to say what facility is better than the other? It depends what you're looking for. As far as the care that you're likely to get once the admission is made, I don't think that the care that's being provided by the staff on the floor is directly correlated to the fact that I may be the attorney, because they probably don't know that I am. However, should something happen where the client needs advocacy, then the fact that I am involved will accelerate the process. For example, if the nursing home wants to make a room change and my client doesn't want their relative to undergo that change, there's a better chance that I can prevent that from happening as opposed to if I was not involved in the case.
Let's get back to the telephone calls. Augie is up next from Queens. Go ahead, Augie. What's on your mind tonight?
Hi, good afternoon. How you doing? I'm going to go down a different road here. My dad died from asbestos lung cancer about 8 years ago. 10 years ago, we filed a civil lawsuit. Somewhere in the interim of that, it was a $200,000 lawsuit. So far, we saw $20,000. It seems that once we signed power of attorney over to this law firm, the money just stopped coming in. And my mom wants to know how could she go about revoking power of attorney, and how do we find out who else is on the civil case with us, and how much money was dispersed to each people in the civil case.
Always scares me a little bit when I hear something laying fallow for 8, 10 years. Again, we don't have...
asbestos claims are unique, and they can take a very long time. And generally they're filed before the person dies, and they're settled considerably after the person has died.
Okay. How can they now
You can revoke a power of attorney generally in writing. You send a letter to the person who's acting on your behalf, stating that you no longer wish for that person to act on your behalf. Preferably, you'll name somebody else, or you'll say that you no longer wish to have anyone acting on your behalf, but you will do so yourself. But a revocation in writing is the way you want to go. Have you talked to these folks? Have you tried to find out what's going on? If you've tried that and have not gotten the results that you want, then a complaint to your disciplinary board of your bar association might be something that you want to do.
Mm-hmm. And also, of course, you've been represented by counsel all these years, have you not?
Yeah, we have been, but like I said, once we send the power of attorney over, the money seems to stop coming. Mm-hmm. And this is a $200,000 lawsuit. We got $20,000 from it. But the question I really have is, how do we find out how many disbursements were made and what amounts of money to the other claimants that are on the civil suit?
Well, again, and this is more of a civil question rather than an elder law question, and that's why we suggest, Augie, that you contact your attorney. We understand about the power of attorney, but you have had an attorney involved in this case and may still now. Again, that's not abundantly clear to me, despite the power of attorney, which again is a legal instrument. You need to talk to whoever has been involved legally in this to find out what your rights may be. Again, power of attorney is one of the issues we're discussing tonight, but again, elder law you can bring in so many different things under this umbrella. Our next phone call is from Barbara in Freehold, and I think this is more on point. Barbara, you wanted to know about caregiver or caretaker agreements?
Yeah.
What's your question specifically?
Well, I was advised that being the primary caretaker of a parent, that I could have a caretaker agreement made up and that I could pay myself and that would be legal.
Okay. We have a couple of folks smiling here on the set, so we'll probably want to find out why that is. Brenda, why the smiles from all four of you?
Well, there can be such an agreement. The question is, who is, what is the state of competency of the person for whom you are caring? If the person for whom you are caring is fully competent and wants to make that agreement with you, that is fine. It can be done at an hourly rate. We do that. We'll take care of the sale of the house at a later time if that's necessary. All of the details are spelled out. However, if the caregiver is a power of attorney and wants to both create the document, sign the document as power of attorney for the person for whom they are caring, I would be very concerned about such a document. I would not do such a document.
Howard?
Yeah, the use of personal care contracts has become increasing over the years, but